Thank you, Paul. All right, well, welcome back, everybody. Today I'm going to talk about disclaimers and also about another bar to inheritance, which is the concept of murder. I mean, they're two different things, really. One really involves an action by the beneficiary that is bad intent. And so we'll cover the Slayer statutes, they're called, and dealing with what happens to someone who murders another person in order to inherit from them, or who murders someone and as a consequence would be entitled to inherit from them. What would we do in that case, and what do states do in that situation? But we're going to start with something I think is you're much more likely, I hope, to encounter when you're in practice, and that is the concept of a disclaimer. Now, I happen to have on the screen right now the Mississippi disclaimer statute, but you will find that disclaimers tend to be very similar in every state. This is just one good example. I put the Florida statute up there. If you're going to practice in Tennessee, you might want to look at the Tennessee disclaimer statute, because what you'll see as kind of a common thread is that a person may disclaim an interest that comes from a will or through a testacy, and a person may also disclaim an interest that comes under non-testamentary interest or contract. So, for example, I could disclaim life insurance as well if I wanted to. Life insurance passes as a result of being a third-party beneficiary contract. So when you talked about those in contract law, you thought, well, when will I ever really be thinking about these? A lot of times those are the types of contracts that are involved in estate planning. So a retirement plan, for example, a retirement plan will typically say who is the owner of the retirement plan, but also who will receive the benefits of the retirement plan at death. Right. So, if for example, my own retirement plan says that if I die before I retire, my wife will be the beneficiary of my retirement plan. That will not pass through probate. That will not pass through my will, because the contract itself already designates who will take the property at death. All right, so it's very important that you talk to your client about all their property when you're doing their estate plan, and ask them if they have any of those types of contracts, retirement plans, or life insurance that will be payable directly to the beneficiary upon death. Doesn't have to go through the estate of the decedent, and but can be disclaimed as well. So you're probably thinking, well, why would I disclaim? Or we look at the Mississippi statute. I won't read it out loud to you because you can do that. But the idea of disclaimer, we're allowed to disclaim even after the death of the decedent. That's really important. We're allowed to disclaim, and the Mississippi statute says you've got to file this disclaimer. It's got to be recorded in the office of the Chancery Clerk. So you need to know, whatever state you're practicing, where you need to file that disclaimer. And you got to do it not later than 9 months after the effective date of the contract, or not later than 9 months after the death of the deceased, if we're talking about intestacy property or property passing through a will. All right, so you have some time. You can sit down and do some planning after death to decide when it might be beneficial for someone to say, hey, I don't want this property. All right, now your reaction might be, well, why would you do that? Why would you ever turn down property that you would be entitled to? Or why would you advise a client to turn down property, or a beneficiary to turn down property they could be entitled to? And we're going to talk about that today. The ability to know what the estate is, the ability to know who the beneficiaries are, and to file this disclaimer within not later than 9 months after death is an important tool, because you don't have to make this decision. Your client or the beneficiary doesn't have to disclaim prior to the person's death. They may not even know they have an interest that's going to pass to them through a will. So they actually have time to kind of consider what the consequences are and what the possibilities are. And that's important, right? I don't know how many of you have watched the terrible game show called Deal or No Deal. I admit to having watched it and watched it often. And the idea of deal or no deal is that a person chooses a box out of, I think there are like 25 boxes, maybe more. They choose a box, and their box contains a monetary amount. And the amounts could range anywhere between $1 million and a penny. And so they don't know what they have. They just, what happens is they start to open other boxes. So as those boxes are open, they don't know what they have in their box, but they do know what they don't have by looking at those boxes. And each time they're offered, to either take what they have in their box, which they don't know what it is, or, an offer from someone called the banker, a mysterious person called the banker. Right? That show always annoyed me because people go on Jeopardy and win, $1,000 for knowing a lot of stuff, and somebody could win $1 million simply because they opened boxes and guessed something in a box. So that always bothered me a little bit. But anyway, I digress. The fact is, this is not deal or no deal. Disclaimers, you could sit down with a person and say, all right, here's what would happen if you disclaim. Here's what happens if you don't disclaim. And when it is a better decision to disclaim, then you can make that choice. You have to file it in writing within 9 months of death. Now, that's an easy date to remember. One, you can look it up always, and you should in practice. But I always remember the 9 months period because you got 9 months coming into the world, 9 months leaving it. So you're going to have to file for your client. They will have to file an estate tax return within 9 months of death. They will have to file a final income tax return within 9 months of death. Obviously, when they are the decedent, they're not going to be filing it themselves. You'll be filing it for them. So there are certain things that have to happen within 9 months after death, and the disclaimer is one of them. So just keep that in mind. All right, so we're going to escape this screen, and I'm going to pull up a PowerPoint presentation about, why would you disclaim? And it's not a long one, but I just thought it would be, helpful as we go through these. Why would someone disclaim? All right, when should you decide not to inherit? When should the beneficiary decide not to inherit? And there's certain scenarios where it makes perfectly good sense to turn property down. Now, one, I didn't put this in the slides, but if somebody died and left me a toxic waste dump, that was going to create a lot of liability for me and no benefit, I could disclaim that. I could say, hey, I don't want this Superfund site that I'm going to have to clean up, or some other asset that is just dripping with liabilities that's not going to do me any good. A dilapidated building in town that's that's being condemned and going to be torn down might not be something that I want to inherit. So I could certainly disclaim that, but there are other reasons why someone might disclaim that may not be so obvious. And so, one reason would be to avoid creditors, not of the decedent. The decedent's creditors will have access to their assets. Creditors will be paid before any beneficiaries are paid. So that's an important part of the process when we talk about probate throughout the class. One of the things that will happen is, as you administer an estate, the first people that have to be paid are creditors. And guess what? This may make you happy, and it should. One of the creditors that gets to jump to the front of the line will be the lawyer that helped to handle the estate. The doctor who was the doctor of the last illness is a creditor that will be paid as a priority creditor. And the reasoning behind that would be that when, if someone's ill and you're a doctor and you realize, hey, I may be their last doctor. If I think that I've got to wait in line behind other creditors that may have come first before I treat this person, I may have second thoughts. Hopefully the doctor won't, but that could be on that doctor's mind. And as a lawyer, when you take on the estate of someone, you might think, well, I certainly will take this on, but there are other creditors waiting in line. You get to jump to the front of the line by statute. And we'll talk more about that as we go forward. But here we're talking about the creditors, not of the decedent. We're talking about the creditors, in this case, of the beneficiary. All right, so let's say you got a beneficiary B. I'll be very creative here and call the beneficiary B and the decedent D. But B is entitled to inherit $20,000 from D, maybe through a will or maybe through intestacy. But B owes $20,000 to a credit card company, and the credit card company has already made plans to write off the debt in a year and just say, okay, you're clean, and and B can move on from there. So B's not really going to have to pay this debt. They're going to discharge that debt for some reason or another. Maybe it's a student loan that B owes, and it's going to be discharged for some reason. It may be based on income or assets that they're going to be discharging it. So in any event, it will not be in B's best interest to inherit that $20,000 from D. So what'll happen is B can file a disclaimer. Now, what happens if B disclaims the money, though? Where does it go? Well, the statutes, every disclaimer statute in this country, so wherever you practice, is going to say, hey, if you disclaim, then we're going to treat you as if you predeceased the decedent. All right, so you'll even know then, or your client will know, when the disclaimer is filed, how the property is going to pass. So let's say I'm B and I owe this money, but I've got a child, and that child will be the taker if I predeceased D. Well, then I know if I disclaim, the money won't go to me, but it'll go to the next taker, who happens to be my child. And so, that's a way for me to have that money passed to my child without going to my creditors. My creditors would not be able to take that money from me because I never had it. A disclaimer is treated as if you never actually, or your client never actually had the money. All right. So even though, the person died, just D died, and even though our beneficiary here was entitled to that $20,000, that beneficiary has 9 months to disclaim, and if they do disclaim, it's as though they never had it. So it's not subject to their creditors' claims. It's not subject to taxes. It's not subject to anything. It's just a wash at that point, and the property will pass to the next person. So that's the first reason, is to avoid creditors. The other might be to avoid an unnecessary probate. I mean, not all your beneficiaries are going to be young. Some might be old. B might be someone who's 92, very ill, not expected to live much longer, and B is not going to get any benefit from inheriting this property, whatever it happens to be, from D. And I said in this case, a large sum. I mean, all that's going to happen is, if that large sum passes from D to B, and then B dies shortly thereafter, we're going to have the property subject to probate in D's estate, and then subject to probate again very shortly in B's estate, and B's not going to get much benefit from the property. So why would we subject this money or property to a second probate in a very short period of time, which means more expenses, more fees, more time lag, more subject to B's creditors at this point as well? Why would we do that when we can instead disclaim? And remember, when you disclaim, you're going to know who that next taker is, who's going to take the property when B disclaims, because B will be treated as having predeceased. So this is not deal or no deal. You're going to know where everything is going to end up. You're going to know what you got. You're going to know what you're giving up if you disclaim. It's just a decision that you should be thinking about every time you administer an estate, because this is a way to engage in what we're going to call post-mortem estate planning, after death estate planning. We're going to know all the facts, and we're going to know when it's in our beneficiary's best interest to turn the property down. Another reason why we would disclaim would be to avoid estate tax. All right, I promised that this class will be 99% tax-free, but we can't completely ignore the estate tax when we talk about wills and estates. Now, in this day and age, very, very few people actually pay the estate tax. I will give you a PowerPoint later in the class that'll take you through all the numbers on this, but suffice it to say that fewer than 2 estates out of 1,000, so less than, not 2%, but 0.02%, 0.2%, 0.2%, excuse me, of the people in this country who die will actually have to pay an estate tax. Their estate will pay it. The way the estate tax works is the estate is the one subject to the tax, not the beneficiaries, the estate. All right. And so the object is that the estate tax is a tax on the ability to transmit wealth to the next generation. Think of it as a toll. In order to transmit large wealth to the next generation, the estate has to pay a toll. But in order to incur that toll, a married couple would have to pass more than $10 million in a taxable estate. And that's important because not everything they pass would necessarily be part of their taxable estate. Well, that's for an estate tax class to get into all the details. But again, with good planning, you can typically avoid the estate tax. And unless the estate is in excess of $20 million, most good estate planners will avoid the estate tax. So we're talking about only very, very wealthy people are subject to the estate tax as of now. Now, that could change. When I was practicing and when I was in law school, the limit was $600,000 or more is what triggered the estate tax. So, at that point, if somebody had $1 million, which, would include their house, would include potentially life insurance they passed to their heirs, which would include their retirement plan, then that triggered the estate tax. A lot more people in the country really were paying the estate tax back when the threshold amount was $600,000. But now that it's, for a married couple, $10 million, that is not true anymore. Very few people pay the tax, which is why it's always surprising to me that people get up in arms and you hear politicians say, we need to get rid of the estate tax. The average person who is in favor of getting rid of the estate tax is under no likelihood or even has no chance of ever having to pay it, myself included. So, it's a tax on the very wealthy. It does generate for our government, roughly over the next 10 years, some $260 billion in revenue. So it's not insubstantial. And there are a lot of people, myself included, and you as lawyers, as estate planning lawyers, probably should be in this pile, who are not in favor of repealing the estate tax because it is the most progressive tax we have. But I'll get off my soapbox because the main thing is, if you had a very wealthy client, and that's B in this case. So on this slide, B, let's say B's got a $20 million estate, doesn't need to inherit anything, but is entitled to inherit something from D's estate. The rich keep getting richer. So, B's gonna get, another, let's say $1 million from D's estate, and doesn't really need it, has plenty of money. Let's say B is older, possibly going to die in a relatively short period of time. The estate tax, once you incur the estate tax, it goes up very quickly to a highest marginal rate of 55%. Now, the reality is only those estates that pay the estate tax really pay an average amount of about 14%. But still, that's, so let's take that $1 million. And if B had to pay, an amount that was roughly 14% of that $1 million, that would be $140,000 in tax. If it was 55%, well, then we're talking, $550,000 in tax, and all on an inherited amount that B really didn't need. Now, notice the tax would only be paid by B's estate when B died. But why put that money in B's estate if we don't have to, if B can go ahead and disclaim? And if B disclaims, it's as if B didn't ever own the property, never had it, she didn't have access to it. And so it'll pass to the next generation. Now, if that next generation happens to be B's children, that's even better because that $1 million will pass directly to B's children without B ever having to have possessed it, and therefore B's estate will not be taxed on it. So for very wealthy individuals, a lot of times when they inherit property or have the right to inherit property, disclaimer may be exactly the right thing to do to avoid a future estate tax and to pass the property to the next generation free of that estate tax. So Another reason why we would engage in this post-mortem estate planning called disclaimer. All right, and then finally, here's one that's kind of the opposite end of that. But many of you will be dealing with people who are involved in disability, who have some type of disability, whether they're in a nursing home because they're elderly or they're disabled as a young person. And so, we need to understand that there's special planning that is involved in planning for incapacity. We're going to have a whole lecture on planning for incapacity. I am going to require each of you to create your own advanced healthcare directive. I'm not telling you what to say in that advanced healthcare directive. You don't even have to show it to me. It's really none of my business. You're just going to have to assure me that you have, in fact, created an advanced healthcare directive. Now, why? Well, because the chances of dying young are much less than the chances of becoming incapacitated or disabled at a young age. And if a person is incapacitated and cannot speak for themselves, they need to have a plan of who will be able to make medical decisions for them in that event. And I think these are conversations we need to have with our loved ones. I mean, I jokingly say my wife is my healthcare directive, and she knows I don't want anything extraordinary done for me when I'm in the process of dying. Okay, so that's part of it. I mean, so part of it is that what we used to call a living will, which is what happens to me if I'm in a terminal situation. Do I want extraordinary medical care? Do I want no medical care? Do I want food, being fed to me through a tube and liquids being fed to me through a tube, or do I not? Do I want that to stop? Do I want pain medication? All of those, we'll talk about that, and they're forms that are real easy to fill out. Every one of us should have that plan, because you don't want to be in a situation where you haven't given anybody authority to make decisions for you. You haven't talked to them about what your wishes would be, because that would be a situation where then your chances of your actual wishes being effectuated is small. Many of you probably remember the Terri Schiavo case. Terri Schiavo was a woman who was in a persistent vegetative state, and she, according to the doctors, had no chance of recovery. Her husband wanted to terminate medical care, wanted to terminate feeding, wanted to terminate hydration. Her family did not want to. They claimed that they saw movement. The doctors all said that was involuntary movement, but it didn't matter. There was a big, long, and protracted court battle over what would happen to Terri Schiavo. If she had had a written advanced healthcare directive, that none of this would have been an issue, because her written advanced healthcare directive, according to the U.S. Supreme Court, is valid and must be given credence. So, we want to have those. But that being said, people do become disabled. And another thing we're going to talk about later in the class is then how to assure that if someone's disabled, that they can receive government assistance. There's nothing controversial about this, by the way. Medicaid is set up to cover those kinds of people, even though their families may have money. We'll talk about in this class about something called a special needs trust that will allow a person to have a trust that has money in it for their special needs without disqualifying them from Medicaid. My wife and I have a niece, her sister's child, who is has severe cerebral palsy and has since birth, and she receives some state and federal aid for that. There is money set aside for her special needs that would not be money that Medicaid would pay for. As long as it's in a qualified special needs trust, she can stay qualified for Medicaid. All right, so these are not bad people that set these things up. This is set up. Medicaid has a plan for setting up a special needs trust with disabled persons in mind. All right. So that being said, let's say you got B's in a nursing home, or B is someone who was born with a disability. They're not going to be able to work. They're not going to be able to earn, but they need care, and they qualify for Medicaid. If B inherits from D, Medicaid's going to seek reimbursement of that money, as they should, as they absolutely should. Many states have provisions that allow Medicaid to seek reimbursement when someone inherits money. All right, but B also may be disqualified from receiving Medicaid in the future because Medicaid is based on assets that someone has. It's also based on income. So, and B is not going to benefit from this inheritance because B is already in a nursing home, being taken care of, and getting state assistance. So there's no benefit in having B inherit this money other than that the state will get a reimbursement. So in this case, it would make sense to disclaim the inheritance and have it passed to someone else. Now, there are a few of you, and I know there's a Chancery Court judge in Mississippi who hates this concept, but again, this is perfectly legal. There's nothing illegal about it. And there are families, even if a family has, $150,000 in the bank, if they have a disabled child, that money is going to be eaten up very quickly. And there are people who argue, well, they ought to use up that money first before they qualify for Medicaid. Medicaid is there to take care of people who cannot afford to pay for insurance, and that would include a disabled person. So whatever your thoughts are about this, to keep someone qualified for Medicaid would be a good time to file a disclaimer. All right. So that's again why we have disclaimers, and I hope this helps you understand that a little bit. All right. When we come back, we're going to take a break. We're going to talk about something that we have not talked about yet, and that is advancements from an intestate estate. We're going to do it quickly because they're really not. They don't happen very often, and we'll talk a little bit about the Mississippi statute. You can see it on the screen right now, 91-1-17. I want to touch on this. Bar exams sometimes touch on it, but in practice, it's really not something you'll run into very often. And then after that, we'll take a break and we'll move into the Slayer statutes. So we'll be back in about, whenever you want to come back. That's the beauty of this. This is like live. This is like watching Netflix. So when you come back, we'll talk about advancements. All right. Let's see. Okay, I'm sorry. I'm going through the PowerPoint because I started it from the beginning. That's good chance for you to see very quickly all the stuff that I'm zipping through. Okay. All right, there we go. Let's go to the advancements then. All right, this is where we're going to start. Forgive me for flipping through that PowerPoint like that. But we want to look at Mississippi Code section 91-1-17. It's the same kind of section that every state has in terms of advancements. Advancements only occur when a person dies completely intestate. That's the first thing. And the idea of advancements is this. I'm going to put it in English because what's up on the screen probably doesn't sound like English to you, but there's a reason why we have these statutes. All right, a common law in the old days, when someone received a gift, a lifetime gift, that gift was considered to be an advancement on their inheritance. And so, for example, if dad gave a child $1,000 during dad's lifetime, then that child would get $1,000 less after dad's death, because they would be considered as having gotten a share of their estate already. That was the rule, and that was the presumption. The presumption that was that every gift received during lifetime counted as a part of a person's share of the estate. Well, I want you to think about your own families. All right, how many of you don't have to raise your hand because I can't see you. How many of you remember what gifts you've gotten completely through your lifetime? I mean, if you had to account for every gift you got from an intestate estate, every gift you got, and then someone died intestate, and you had to account for every gift you got during their lifetime, it would almost be impossible to do. Think about every birthday present, every Christmas gift, every gift that was just for just being there. All right. So what we've done with modern statutes is we have reversed that presumption. Now the presumption is gifts do not count towards inheritances. They do not, unless the decedent has put in writing something saying this gift will count towards your inheritance. So, the important thing is you're not going to see too many actual written advancements in practice, because if someone takes the time to write down a statement, this $1,000 will count towards your inheritance. If somebody takes the time to write that down, then they're probably going to take the time to create an estate plan. All right, so I want you to think of Code Section 91-1-17 really as being a way of saying the presumption is if it's not in writing, a gift does not count towards someone's share. Now, I do think it's important as you enter into practice to think about advancements, not because they happen very much practically, but because in reality, your client probably has given some gifts during their lifetime, and they ought to at least consider whether those gifts should count towards a share of the estate. If you're going to do a will for your client, then you can account for those gifts by giving someone less if they've received a substantial gift. So I'm going to give you an example. Let's say that I have 3 siblings, and I go to my parents and I say to my parents, I want to start a business, and I could use a loan of $100,000 to start this business. And my parents say to me, "Well, I'll tell you what, we'll give you that $100,000 as a gift." And then my parents die, and they die with an estate that has $500,000 in it, let's say. Now, if there's no planning involved, the presumption is going to be that my gift is just separate. My $100,000 is separate, and that I will take an equal share then of the remaining $500,000 in the estate. I know. From a fairness perspective, though, my 3 siblings then are going to get less because I've already taken that $100,000 that would have been in the estate out of the estate. There would have been $600,000 in the estate if I didn't get that event or that gift. And so we would have each got $50,000. Now I'm going to get more than that, and they're going to get less than that. Do the math. I mean, I'll be able to get it, but you could do it. Right? So if you think about it, they're going to each order $100,000, and that is only $25,000. I'm going to get $25,000 in addition to $1,000 I've received. So I will get $225,000. Now that may be what my parents want. But it's an estate planning where you need to ask your clients, have you made any substantial one child to another? Do you want to take that into account as you plan your estate? Because it does make a difference. I had a I'll call him a friend, but there was a guy in college that was really truly the person who always found a way to need to borrow money or something like that. But and he was the guy who, when I would go to a pizza place with him, because he said, "Hey, I got a 2-for-1, buy one get one free coupon." He was the guy who would then insist that the free pizza should be his because he had the coupon. So this guy really has this. And one of the things that, I don't know why, you're probably going to think, well, I was stupid to go get pizza with him ever again. And I did go get pizza with him again because I generally liked the guy. He was just kind of quirky this way. But he insisted one time that the pizza place cut the pizza in 16 slices instead of 8 because you got more pizza that way. And I hope you're laughing, because you don't. You get more slices, you don't get more pizza. And think of an estate that way, because there's only so much to go around. And if some of it has been distributed while the decedent was alive, in lifetime gifts, then that money will not be there. That property will not be there to distribute after death. All right. So advancements are a way for a client who has an intestate estate to take into account lifetime gifts. They're also, even though we don't call it an advancement, because advancements only apply to intestacy, but it's a conversation you need to have with your client about those gifts that were made during life and whether they should count towards a child's share when you make the will. Okay, so again, we talked about the common law rule, the presumption that advancements are in fact every gift is an advancement, but we overturn that common law rule with modern statutes. Now, the purpose of the rule is to try to equalize the estate and consider, lifetime gifts in addition to after-death gifts, just out of fairness. Now, we'll talk about this concept of the hodgepodge. The best way to do that is going to be with an example. We'll see that in just a minute. But the statute, the Mississippi statute, talks about this hodgepodge. So what on earth is that? All right, so here's an example that I hope will explain all of it. All right, so this parent has $450,000. Parent gives $50,000 to child A. Parent dies with $400,000 and 3 children, A, B, and C. All right, so if the court determines the transfer was an advancement, and by the way, an advancement is a term of art. It's got to be in writing, and the writing has to be contemporaneous with the gift. If the writing is made by the donor, it has to be contemporaneous with the gift. Let me explain why that is. All right, so if I give this $50,000 to child A, in order for it to be an advancement, I have to die intestate completely, and I have to say, when I make this gift to A, I have to put in writing, I am giving you this $50,000, but it will count against your share of the estate when I die. Then that's an advancement. All right. Now, it's got to be contemporaneous with the gift if I'm the donor. So I can't, for example, give the $50,000 to child in June of 2017, and then 6 years later get pissed off, excuse my French, but hey, we're all adults. I can't get mad at my child and say, that $50,000 I gave you 6 years ago, that's going to count towards your share of the estate. That can't be an advancement. Now, I could write a will, and I could take $50,000 out of what I was going to give my child by my will. That's a different issue. But if I die intestate, no court is going to allow that statement 6 years later to count to have created an advancement. So that child will still then get a full 1/3 of the estate. All right, so the bottom line of this is, if this $50,000 is an advancement, it's going to count. It's going to reduce A's share of the estate ultimately. But if it's not an advancement, then parent dies with $400,000, and A, B, and C are each going to take $133,000 and some change each. They're each going to take 1/3 of that. But if it is an advancement, and the court decides it's an advancement because it was in writing and contemporaneous, then we're going to have something called the hodgepodge. Now, why they call it a hodgepodge, I don't know. This all comes from common law England. But the bottom line of this is, all we're saying is, okay, well, what would the estate have been if we never gave that $50,000 to child? All right, because what we're going to do is hypothetically put this $50,000 back into the estate, just hypothetically. So there's $400,000 in the probate estate. We had a $50,000 advancement. Had there been no advancement, we would have had $450,000 split three ways, which would have been $150,000 for each person. So from what's left, from the $400,000 that's left, in other words, B and C will each get $150,000 of that $400,000, and A will get $100,000 because that $100,000 from the estate plus the advancements of 50 will add up to $150,000. Okay, so the difference is if it's an advancement, we hypothetically put the money back into the estate to try to make an equal distribution. Okay, if it's not an advancement, they each get $133,000 out of the estate, and A gets to keep that $50,000. So at the end of the day, A is going to have gotten $183,000, while A's siblings only get $133,000. So this equalizes the estate. That would be the purpose of calling something an advancement. By the way, A could at any time, A could at the death of his parent, even later, even within 9 months, say, hey, you know what? That $50,000 parent gave me, 20 years ago is an advancement. So the recipient can always call it an advancement. They can, in essence, disclaim a portion of the estate at any time. The court's not going to look twice at that. But if the parent wants this to be an advancement, they have to do it, say so in a contemporaneous writing, that this amount will count towards the child's estate. So if you can understand this green right here, you can understand anything I give you in terms of advancements, because that's really all it is. Now, what about this? Here's something I want to add. All right, let's say there's less than $50,000 in the estate. Let's say parent dies with only $20,000 in the estate. What happens then when parent has already given 50 to child A? Well, then that's it for A. That's all A gets is that $50,000. A doesn't have to pay anything back, but B and C would split the remaining amount equally. So the only reason A would then participate in the estate, we'll talk about it, we call it participating in the estate, is if A is going to get an additional amount above what A got as an advancement. So I hope that makes sense. All right. Remember, the problem with the rule at common law was we would be having to count up every gift ever made to a person in their lifetime, unless we had a statutory rule that changed that. And that's why these statutory solutions say, hey, it's not an advancement unless it's in writing. It reverses the presumption that every gift is an advancement. Now, when you think about estate planning, you're going to be dealing with real people. And I can even think about my own family. I use my daughters as an example, and I hope I don't embarrass them. But just by living, I think sometimes I do. And we have an 18-year-old and a 16-year-old, and if we give the 16-year-old a new cell phone when she's 15, which we did, then the 18-year-old reminds us that she didn't get a new cell phone until she was 17. So, you're going to get into these situations with families where everybody feels like they're being cheated to some extent, right? And you got to talk to your client about that and see what they really think is fair. I mean, as a parent, I will say we try to take care of the needs of each person as they come up, and needs are different. So when you do estate planning, you need to figure out, well, how are the needs of various children different? Younger children have different needs from adult children. You may have a wealthy child who's, an oncologist who does really well in medical practice, who may not need as much as a child who is struggling a little bit. And so you want to talk to the parents about that. So another problem with advancements is then they basically say, hey, we're going to assume that if somebody got something ahead of time, that was unfair. And that's not necessarily the case. All right, now let's take a break, and when we come back, we're going to talk about homicide. We've already talked about disclaimer, but we're going to talk about the bar to succession that is not one that you're going to use in planning. Disclaimer is one that you'll use in estate planning when we come back in just a minute, or whenever you decide. Okay, welcome back, and I'm not going to flip through the PowerPoint this time, so I did better. Homicide. All right, so what should we do? Let's put ourselves on a desert island. And you got a situation where someone knows they're going to inherit. This is the old, you've seen this a lot in crime movies where I know I'm going to receive life insurance from somebody or I'm going to inherit from them if they die, when they die. No if about it, but when they die. And I decide, well, I could wait a few more years, but really, I need cash now, like the old J.G. Wentworth. I won't sing to you, but I need cash now. I guess I just did. All right. So, I decide I'm going to move the process along by poisoning their food. What should happen then? I mean, how should that be treated? Should I be able to inherit from someone when I've actively been involved in procuring their death or causing their death? And I think we would all say, as society, on our desert island, no, that wouldn't be right. Why should we allow that person to inherit? So then the next question would be, well, who should inherit if they don't, and what standard of proof are we going to prove this homicide, this death? I mean, what about this? I mean, what about a situation where I've been drinking too much and I've got somebody in my car who happens to be my parent, for example, and I'm going to inherit from my parent when they die, and I drink too much and I get unfortunately into an accident. My parent dies because of my drinking. That could be vehicular homicide. That could be manslaughter in some cases. Would that be the kind of homicide that should keep me from inheriting? All right, right now, that's just a question. I'm going to leave that as a question for you to decide whether you think it should be. All right, and what level of action should it be? Now, what about negligence? What if I just am negligent and I don't intend to kill anybody, but clearly I'm at fault in causing their death, and I would inherit from them? Should I be prohibited from inheriting from someone based on mere negligence, even though the result was horrible? So when we look at how states deal with death caused by the beneficiary, we're going to see some different results. All right, now N. Ray Mahoney was one of the first cases dealing with this whole issue of homicide, and it was in Vermont, and Vermont had no slayer statute. And in fact, you will find that there are states that don't have slayer statutes, and we'll have to talk about what happens in those cases when someone kills a person and is entitled therefore to inherit from that person by intestacy or through a will. What should we do in that case? All right, we think about O.J. Simpson, and we think about the fact that he was acquitted, and he was found not guilty of having killed Nicole Brown Simpson. Now, if he was allowed to, if he had been her beneficiary, would he be prevented from inheriting, even though he was acquitted? Or is there another process we can go through to try to prevent someone from being able to inherit even though they are acquitted? So what are the effects of criminal conviction? Well, we're going to see that criminal conviction, whether there's a statute or not, will prevent someone from inheriting. All right, and they should. And I think we're going to see that in every state. So if someone is convicted of unlawfully and intentionally killing another person, they will not be allowed to inherit. Now, states say that different ways. Some states say feloniously and intentionally. If you look at Florida statute, there's that word feloniously and intentionally. All right, but it all comes to the same conclusion, which is if you have a client who in some way engages in unlawful activity and intentionally kills another person, they should not benefit from their actions. And I think that's just, that's common sense. All right, now if you're acquitted, as OJ was, what happens? Well, we're going to find that there's a separate process that can take place, and that's a civil process. Someone who is not criminally convicted by a standard of beyond reasonable doubt could still be found in a civil court to have more likely than not, so it's a lower standard, caused the death of the person unlawfully and intentionally. So you're not going to go to jail for it, but can be prohibited from inheriting. And that's exactly what happened in the O.J. Simpson case. He was found to not guilty of the criminal charge, but was found more likely than not to have caused the death of Nicole Brown Simpson, and so he could not benefit from that crime, and that really affected then. Really, in some ways, it was a wrongful death case, and there were civil damages that he had to pay to Nicole Brown Simpson and Ron, I forget his last name, but the other victim of the crime, and so he had to pay damages to those estates. Any proceeds he got from books, for example, and movie rights would have to be paid to them under that court order. And so if he were to have been a beneficiary of either of those parties, he would not have been allowed to inherit either. All right, so what do we do, though? Let's go back for a second to the situation that I talked about with Vermont. And so what do you do when there's no Slayer statute? Well, in that case, what we're going to see, and by the way, those of you that practice in Texas will run into the same problem, is that